Hey, everybody, we're going live tonight everywhere. Hope you guys had a great day. So, today we missed a radio show. My producer said he had to take his cat to the vet to get the stitches removed or something. But it looks like he had a show today, so I don't know. We're not worried about that. We're just going to move on with our program. So, welcome to Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. So my name is Neighbors, Coach Neighbors. For those of you who don't know who I am, that's who I am. And today we are going to have a team meeting. And in this team meeting, we are going to talk about things that team members need to know. We're going to cover quite a few things. So today in the team meeting, we're going to review some of the most important questions that came up during the week. And we're going to talk about, we're going to take your questions about the lawsuit packages. If you have any questions, we'll take them about the lawsuit packages. We're going to review the statutes that's used to allow corporate officers to register your deed in their office. And we're going to clarify some and make sure that we all understand that. There's some confusion around that statute. And so we're going to take a look at the statute and look at the wording. And hopefully when we look closely at the wording, you'll be able to navigate through the confusion. And some of the confusion is that the statute is the law that forces people to register your property deed in their office. So we'll check that out. We're also going to cover what a constructive delivery is. And we're going to talk about real estate deed fraud. And I'll tell you right now, if you understand the real estate deed fraud, you will be able to keep up in my program and understand what's going on. The real estate deed fraud, that is the beginning of the problems that allows the foreclosure to take place. It allows the liens to be placed on your property. It allows the city to start enforcing code enforcement and property tax, all of that stuff. We're gonna talk about that. And you guys are gonna receive some tips on what you need to do to make it down this new journey that you're on. So, and if we have time, we're going to cover a couple new projects that we're working on. So that's kind of what we got lined up for the day. We've got a lot of stuff lined up for the day. Do a new online course. One of the things that I'm thinking about putting together is a new online course to block code enforcement and eliminate property taxes. This same course would be perfect for people who have Airbnbs that are getting challenged by the city. And that's basically what the course started out is about. But I'm able to put all of these things in it because the course to challenge the Airbnb, the city's illegal conception that they have control over people's private property, all fits together. So the property tax issue, the Airbnb issue, all of that stuff is around the city's misguided control over the deed to your property. So we're going to talk about that and how you need to go about getting control of that. And we also structured an acceptance to the attorney's contract document. And actually it's a package because it's several documents. And that's a real interesting project that we're working on. And we're actually in the process of using that document. And I think in the Facebook page, I talked a year or so ago about a very good friend of mine that was like a family member that I was helping with her judicial foreclosure. And she's still in her house and attorneys are in default. They were not able to answer to the jurisdictional challenge with affidavit. They were not able to respond to our motion that we filed to dismiss for failure to litigate the case. We decided to give them opportunity to dismiss it on something other than the lack of jurisdiction, because they don't like to do that, and have that on record for other people to use. And we're figuring out how to work this in our favor So our number one goal is to teach people how to stay in the house. So that's the number one goal, to teach people how to stay in their house. So if you're still in your house, then the goal is working out. Now, aside from that, then we also want to make them go sit down. And that's what my program is structured. My program is not structured to go before the judge and have the judge rule on this stuff and all of this stuff, because that never happens. And that's one of the reasons why I tell you, don't spend so much time picking. I've done my homework, okay? But if you're about to get jammed up, you need to get the stuff filed so you can pick at it later, okay? You don't need to spend so much time picking. You need to get it filed. You need to get your stuff filed. Our goal is not to get in court and go before the judge and have the judge say that, well, the judge is never going to say that we won anything. So I don't even know what I'm talking about there, but you know what I'm saying. Our goal is to get on the record what you need for your lawsuit and force them to go sit down because of the shared liability. They start to visualize the shared liability, and then it becomes a problem. Remember, what we take to the table is stuff they don't want to talk about. So they don't know how to handle it when you are in court with a different goal than to just do what they want you to do and go before the judge so they can argue. Because when the arguing starts, the judge gets to help them. That's the way their program is structured. It's pretty simple to me. So if we go in with stuff they don't want to argue about, then we're doing good. It's kind of like who can hold your breath the longest. And I had a guy tell me one day, well, I don't want to just be in court all year. I said, well, go pack your shit. I mean, come on. We have a plan here and we're doing this. The number one goal is to stay in your house, not to get your house free and clear, or not to go after the bank. A lot of people get emotionally wrapped up in going after the lender. And that's the number one problem that, in my opinion, that most people have that's fighting foreclosure. They have the wrong person listed as the number one defendant. The lender did not sign any of the paperwork anywhere. It's the attorney acting as a third-party debt collector. And until you get that, you're going to be struggling. So that's just the way it is. I've been doing this for a minute. So let's just get started. So the first thing we want to talk about is the jurisdictional challenge with an affidavit and the procedure for that. People are missing the boat because they're standing around waiting for the judge to, I don't know what they're waiting for. If you read the document, you'll see that you're ordering the judge to force the attorneys to respond on the record and by counter affidavit. Now, having that affidavit on the jurisdictional challenge is a great idea because we already know that everything they're doing is fraud. So they can't respond by counter affidavit. So that's the problem for them. So what they rely on when they can't respond is help from their judge buddy. And some people have made it very easy because they did not review the federal rules of civil procedure to find out how long these attorneys have before they have to answer. Now, some people think that the attorneys don't have to answer until the judge orders them to. Now, that's BS, and you need to go start packing your stuff. I'm serious. You need to do your research. Now, when you whip out the federal rules of civil procedure, I know stinking books about that thick, and yeah, but you know what? You can only do one thing at a time, one step at a time. So if you're at the process where you're filing something and they're supposed to respond, then that's what you need to look up. How long do they have to respond? And you should already have your document prepared to address their non-response, because I'm telling you right now, they ain't going to be able to respond. And if they do, they're not responding by counter affidavit, so it's a non-response. So you should already be figuring out what you need to do. That notice of default document should already be prepared. The same day that the same day they're supposed to, the last day they have to respond, you should be down filing that stuff right in their face and demanding the case be dismissed. Yep. But what's going on is people are waiting and waiting for the judge to respond. The judge don't get to respond when you challenge the jurisdiction of the court. When you challenge subject matter jurisdiction, the judge does not, any jurisdiction, the judge is not the one to respond. Now, If the judge does take over and respond, now it's time to get your reconsideration package out and whip out the motion for reconsideration. Attach all of the documents, the file stamp document that you filed in the case in the first place that they're ignoring. Attach all that stuff to your motion for reconsideration and stick it back in the judge's face. And then the next day, you want to go back and file your motion to recuse the judge. And after you file that, and you don't want to give them all of your stuff at the same time. Just give them one document at a time. Oh, yeah, my legal team told me to file this too. And what about your next document? That's how you got to do that. You don't want to give them all your stuff at the same time, because then they'll go over there and start picking at it and come back and start giving you a hard time. Just do it one at a time, one document at a time. And then when you get done filing your motion to recuse the judge and they file stamp it and give you your copy, then you can file your notice of claim against the judge for violating your constitutional rights for taking jurisdiction without judicial authority. Most people don't realize that you're in an administrative court, period. And you have to force the court to operate on the judicial side by doing all of the things that we teach you how to do. Pretty much you're going after the attorney. And that's the number one defendant in the law firm. And that pretty much shuts them down, it throws a big wrench in their program. Okay, so the jurisdictional challenge with an affidavit is the best document that you can use if you're struggling and you're facing foreclosure and you're struggling with your finances, you can't afford the package or can't afford the online course. That document is $200. It's still on sale. I put it together for the online course and I left it at the $200. Now, the online course students have all new documents that are totally restructured and the bomb. So we left this for the people that are using the lawsuit packages. And the idea behind using the jurisdictional challenge with an affidavit, and if you call me and you ask me about it, you need to say the whole thing, because I have several documents to challenge jurisdiction, but none with an affidavit. This is the only one with the affidavit. So you have to say the jurisdictional challenge with an affidavit. If you don't, I'm going to correct you. And I'm not going to help you until you do, because naming the document, the complete name that's written on is very, very important. Because if you tell me a document and it's not, and you don't tell me the correct name of the document, I'll think it's something else or whatever. I'll tell you, no, you can't use that or whatever. And the whole time, then you get your butt kicked in court because there was a miscommunication. So I know some people get a little grumpy with me when I'm making them say the whole thing, and they think I'm being nitpicky, and I am, and I'm doing that for a reason. And the last person that asked me to settle down and relax ended up getting evicted from his house. And then I had to explain to him later that that is the reason why I was getting grumpy with him, because I can see what he was doing and where it was going to go. But some people have a hard time listening to the coach. So I hope that's not you. Is that you? Okay, never mind. I'm getting a little carried away. So let me stay focused. So you want to make sure that you know what the time frame is for them to answer, because that's paramount in sticking this up in their face. If you allow them all this time to do all this stuff, they're going to assume you don't know what the hell you're doing, and they're going to throw you under the bus. And they're going to keep throwing you under the bus until you earn their respect. And when usually what I tell people is, the first time the judge throws you under the bus, you need to smack him in the face with the documents that you have. And if you don't do that on the state level, they'll make a phone call. When you file your stuff in federal court, they'll make a phone call, and federal court will do the same crap to you. I got people in the group that's going through that right now. That's how I know this stuff. And that's the beauty of the group. The people in the group have helped me put this program together that's helping everybody right now. So it's team effort. And in the group is where I'd like you guys to communicate with me, because I don't have time to take all of your phone calls individually about questions that, well, no offense, because some people I yelled at them and I shouldn't have been yelling at them to go and find it because it wasn't there or their situation was different. But a lot of times it's there. I have people ask me, hey, do I have this in my package? Well, check your freaking package, because I don't have time to answer stuff that you already can find out on your own. Because my job, and I know people hate it when I say this, but I'm going to say it, my job is not to make it easy for you. My job is to help you learn how to stay in your house. Okay, so with that being said, I'll get off of the soapbox. So one of the things that we're considering doing with the documents to assist the standing of a document is to place the document on the public record. Now, I know that's a little complicated with this COVID-19 stuff going on and shit, because you can't just go down there and do it yourself or whatever, and then you got to stand outside, you got to call and make an appointment. But I'm throwing it out there anyway, because if you're in a situation where they're ignoring you or throwing you under the bus or whatever, or playing games, this is a good thing to do. And I want people to do this that who can do it, so we can see if your documents carry more weight. Now, when I put together the marriage dissolution and was teaching people how to get a divorce without the other party's signature and without paying an attorney or the court a whole bunch of money, I ran across the fact that anytime, and this is what they do with your marriage license, they place it on the public record. And once it's placed on the public record, it's considered to be in common law jurisdiction. And really, that placing the marriage license on the public record is what makes everything legal. So the process that I put together for that is the same process they use, except they don't want you to, because they want you to have to pay a whole bunch of money and all this crap to get a divorce, when if there's nothing that you need to be fighting over, then you don't need to pay all that money and do all that stuff. So that's why we want you to place them on the public record, because I think it gives your documents a little more weight in court. So the players have to be a little bit different with it, but we'll see how that works out. And like I said, I want you guys to communicate with me in the group. If it's an emergency or something, you can send me a text message or an email. But I'll tell you, most of the time, if I'm online, which I am most of the time, and you have a question, you can hit me up in the group. It's a lot easier for me to answer it while I'm in the group, while I'm on the computer and doing something, just to take a second to put over it and type it in over here, than it is to me to shut everything down that I'm doing and turn my brain off and pick up the phone when I already have a lot of people calling in. So I have all the new people calling in. The other goal is, at some point where I'm almost there now, the phone issue is becoming something that we need to take a look at, so that I can make sure that people's questions get answered in a timely manner. Now, when the questions are asked in the Facebook page, then other people see the questions, and I'm sure that somebody else has the same question. And so you can see how that helps. Now, the other way it helps when you ask me questions in the group is that members of the group that have already been to pass that procedure or been at that point can also help. And that's why we structured the group and have it set up the way it is. So people that have already done these things can help when you have a question. Now, when people ask a question or ask for help, I want you guys to remember, we don't need to start talking about what the attorney did to you or what you did to the attorneys, because that's not what we're doing here. What we're doing here is non-conventional. So if you're going to offer help or your opinion, it should be based off of the non-conventional program, and maybe based off of your experience in the program and what you've been doing in the program. Okay. We don't want to spend a whole lot of time talking about attorneys. And you'll see, if you call me and you start talking about your attorney, I'm going to tell you, look, I don't want to hear about the attorney, because I already know. I've been doing this for a minute. You have no idea how many attorneys I've. So you see what I'm saying with that. So in the group, if you're helping someone, we want to make sure that you're bringing up what you've learned since you've been in the group, and anything or ideas that might help us in the non-conventional strategy. Those are always open, and I'd like to hear them, because I'll tell you right now, I've learned a lot of stuff from people, from throwing it out there and asking people to tell me what's on their mind. And I had one Korean lady who filed her lawsuit, and she called me up and she said, Mr. Guy, I filed my lawsuit in another place. I'm like, another place? Where the hell else could you file it? So I said, well, where did you file it? She said, one of my friends told me to file the les pendants and attach it to the les pendants and file it where the deed is at, in the county recorder's office. And I was like, oh. And she said, well, did I do good? Is everything okay? And I said, oh. She said, oh, that doesn't sound good. I said, oh, no, I'm sorry. You did good. I'm just saying, oh, I'm thinking, why the hell didn't I think of that? But anyway, so yeah, that's a great idea. So you file your lawsuit, a file stamp copy of your $5.5 million lawsuit, attached as an exhibit to your list pendants, and file it in the county court's office next to. Because see, here's the deal: these attorneys don't tell their clients, a third-party buyer, what's going on with the property. They ain't gonna tell them that there's a lien. They ain't telling them shit, and I'll tell you why. Because the attorneys are so used to stomping everybody in the face and taking everybody's stuff that they ain't worried about telling them, because they know they're gonna have it worked out in the end. And you know they're gonna have it worked out in the end because they're gonna get to argue. And remember, when the arguing stops, the judge gets to help them. That's how their program is structured. Pretty easy for me to see. So that's how that rolls. Now, one of the biggest problems with code enforcement and property tax collection is the real estate deed fraud. Now, this is huge. And at some point when I get these two projects I'm working on now, I'll have a lawsuit together to address the real estate deed fraud. That will handle the foreclosure, the code enforcement, the Airbnb crap. It will handle all of that in one document. Yeah, I'd like to make one document be the bomb. And that's what I did with the jurisdictional challenge with an affidavit. That document is the bomb. And when they can't respond to it, you can add that to your federal lawsuit as an exhibit to show that they could not respond to your challenge of jurisdiction in state court, and therefore had no standing to oppose your demand in federal court. And I would ask the federal court to schedule a settlement hearing. I'm serious. Because you showed it right there. They could not respond to your jurisdictional challenge in state court. They ain't going to be able to respond to it over here either. So why should we have to go through all the rigmarole when you got the goods on them already? And they think they're so smart. Yeah, I love it. I love my job. So let me check and see how many people we got watching. Hey, we got some people watching again. Hey, Phoenix Ace from the Facebook page. I got some Facebook users. Noel, how are you and your wife doing, Noel? Hi, Patricia and Terrell. Welcome, guys. I hope you guys are learning. That's what we're here for. Let me change the banner. Okay, there's the email address in case anybody has any questions. Oh, what I'm thinking about it. So one of the projects that I'm working on is I'd like to put together a package for the HOA, because the HOA people are really, really out of control. But I need a copy of the indenture trust agreement, because I need to review that. And I already have an idea how I want to take this, but I just need to double check, because I like to slam the back door shut and put some screws here so people can't. Yeah, that's what I like to do. So I need a copy of the indenture trust agreement, and also need a copy of the covenant something restrictions. So if you have a copy of that on a PDF where you can email it over to me, please let me know first, because I don't want to have 75 emails with all these documents. I only need a couple. Email me and let me know, hey, do you still need the document, the HOA documents? And then I'll tell you yes or no. And if I do, then you can send those over to me, and then I can use them to structure the new program that I want to put together. So Noel said, yes, we are learning. Hey, Mr. Turner, welcome. And we're going to get to your questions here a little bit later on. So the other thing that I want to do too is I want to have this team meeting thing on a regular basis. And I'll decide how often based on the questions, because what I want to do is the questions that people ask me that are worthy of talking about. I know some questions I might tell you you're killing me here. Okay, but I'm trying to be a little humorous, but also to let you know that the question you're asking me is within your reach. So you need to do the work to find that, because like I said, I'm not here to make your job easy, but to teach you how to do it. So what I want you guys to do, if you have questions about the process or the program or something, and it's important, something that is affecting everybody as a team, then you need to let me know what the question is. And if I think the question is that important, then I'll add it to my list to discuss in the team meeting. So this will give us the opportunity to work together, and it'll give me opportunity to field your questions too, which we'll have. So if you guys have questions pertaining to the lawsuit packages and stuff, then now I want you guys to remember the eliminated property tax lawsuit package. I don't have it. It's structured to kick butt, as you can see if you get the package, but the things that you got to do, who actually you have to place on it, those things, I don't have all of that stuff mapped out. You're going to have to figure that out. And the reason is because, well, every state's different. Some states have a set tax assessor. Some states have a county recorder's office. Some states have and one of the questions that came up was that one person had filed their tax, had re-registered their property deed. After it was initially registered or whatever, they re-registered it again. And the question was, well, who do you add as the, So in that case, you're going to have more than one person, okay? Because in my mind, okay, the ideal situation would be the person that actually filed it in the case. Now, you can still add the person, because, your argument would be if they hadn't filed it in the first place, I wouldn't have to refile it, because I was trying to do, when I refiled it, what I'm doing now, but I didn't realize how bad you guys were lying to me. And that's kind of how I put it, because they did not disclose to you that the pitfalls that you're going to be facing when you registered your deed to your property in their office. They didn't tell you that you didn't have to do that. There's no law that mandates that you have to register the deed to your property in their office. And believe me, I've had attorneys pissed about this and attack me on my ads and stuff and start talking crap. And I just, dude, show me the law. Okay, so the statute is not a valid law anyway. We'll go over that later. But you know what? Let's just start with something. Show me the damn statute that says that we have to register our shit in your office, and I'll shut up. But I'm not going to wait forever for it. In the meantime, I'm going to keep talking. Yeah, I mess with them people. And nobody can show. So if they can't show you a statute that forces you to file your deed in their office, they're full of shit. I'm sorry. They're full of crap, and they need to get out of your face now. I have people file this. I have, I think her name was Sarah. I don't remember her last name. She left a really nice review on my Google review page about eliminated property tax. It was about that long. And when I called her back 3.5 or 4 months later, she told me she couldn't discuss it with me. And she said, I love you, and she hung up. Of course, I'm like, what the hell was that? And it took me a little while before I figured it out. What I figured out is that they came to the table and made her some kind of a settlement offer. And you know what they do when they make you an offer, you got to sign that you're not going to disclose, a non-disclosure statement, that you're going to keep your mouth shut. And I tell people, the goal is the goal. So in the property tax thing, the goal is to get control of your deed, or whatever your goal is for that. So if the goal is the goal, then who cares if you have to sign a non-disclosure statement? I don't give a crap, because I don't have to post all of these things to show people that we're winning, and because there ain't no winning. You're making them go stand down, and they want to make sure that none of that shit's on the record, because they don't want everybody to know. And I get that. I don't care about everybody knowing. What I care about is the people on my team that's trying to save their property and stop the eviction process or whatever it is they're doing. Whatever your goal is, that's what we're here for. At the end of the day, it's kicking attorneys in the face, up in the face. And so that's what the goal is. So, and I have people telling me, no, dude, you do what you got to do. Because at the end of the day, the people who ask me, how many have you won? I'm thinking, call me back when you get a little more desperate, okay? Because what I'm telling you is true. There is no law that forces you to put your stuff in their office. So how many you win pretty much is going to depend on how much guts you got. If you got the guts to step up to the plate and get up in their face, or if you're going to be scared and go sit down in a corner when they start yelling at you, because they're going to be yelling at you. You bring my stuff to your table, they're going to be a little pissed off. And I tell people this, if you're in court and the judge ain't mad, you're getting your ass kicked. It's plain and simple. Okay, you're getting hosed. If they ain't pissed, you're getting thrown on the bus. That's the way you got it. Because the only thing they have to use is intimidation. Because their whole process is built off of lies. And when I say process, I'm talking about all of it, starting with the attorneys having a license. Attorneys don't have no damn license. And I got like maybe 5 or 6 videos addressing that. And whenever they try to get in my face about what I'm doing, I'm right back law without a license. Oh, hell no. Show me your license first. You don't have no license. I'm not talking about your bar card. I'm talking about a license from the state with your picture on it, with a number I can call and reference your ass. Yeah, no, I'm not talking about the bar card. And I tell them the same thing I just said a while ago. Show me your license and I'll sit down and shut up. But until then, I'm talking shit. So that's how we roll. Okay, a couple of new people in. James Galley, welcome, James. And they got some more Facebook users. Okay, she won. Well, so that must be someone talking about Sarah, the lady that had the property tax issue. Well, it depends on what you call winning. So for me, if she achieves the goal that she set out to do, which was to get the property tax out of her face, then she's won. Well, hang on, she's winning. Now, for me, getting control of your deed is then I can say that she won if she has control of her deed. But I don't know. She may have settled for whatever. And I'm thinking whatever was better than what she was facing in the first place. Now, I have another person named Roger Bordeaux. I can't pronounce his last name. He's in our Facebook group, and he's got him backed up against the wall pretty good. And he told me a month ago, 4 or 5 weeks ago, that they actually removed his property from their website, which he was impressed with. They'd done some other stuff, and we reported on that. But the end thing was they had removed his property from the website. But as far as my knowledge, he doesn't have control of his deed, which is still the #1 goal. Because I've had people tell me they've done these other things and got their property off the tax scroll, but after a year or two, they put it back on the tax scroll. So that's kind of how they roll with that. So that's why you have to get your deed out of their office so they don't have any evidence of it, of your property information, and then they can't be up in your face. So let's talk about we're going to talk about the real estate deed fraud. So the real estate deed fraud starts because each state has a law, and the law for deed transfers states that the deed, after the sale is done, the deed is supposed to be delivered to the new property owner. That's what the law says. Look it up. And I'll tell you right now, I'm not telling none of you to take my word for it unless you're about to get kicked out of your house. Then you got to take my word for it and file the stuff. But still, look it up for yourself, because what I provide for you is opportunity here to sift through a whole hours and hours and hours of freaking work to get what I have. And then you can take what I have and do your own research on it. So The real estate deed fraud. No one has, did you get a copy of your deed after you were done? Did they deliver it to you? No. They do what they call their constructive delivery of your property deed. And we want to show you what the constructive delivery definition is. Let me get a screen share here. So, oops, that's not the one we want. That's the next one. This one here, constructively. So this is what constructively means. In a way that has or is intended to have a useful or beneficial purpose. Or in law, that's as an adverb in law, in a way that is not obvious or explicitly stated, but may be inferred. So the constructive delivery. So what that means is a constructive delivery is the attorneys, or they trick you into doing it. But in most cases, the first time your deed is recorded, is registered, is done by the title company's attorneys. I'm just going to call them attorneys. Okay. So the attorneys, instead of delivering your deed to you, they do what is called their constructive delivery, and they register your deed in the county recorder's office. And they make you think that that's part of what you have to do. But there's no law that says you have to do that. And I'm going to tell it to you straight. I have spent a lot of time on this, a lot of time trying to figure out where the beginning is. Where is the beginning of the fraud and the foreclosure? It's right here in the real estate deed fraud. That's the beginning. And I will tell you why. The reason that is the beginning, in my mind, is because when you purchase your house, when you sign that promissory note, and a lot of times the mortgage too, sometimes they're both processed through the Federal Reserve for the electronic credits that they're saying is the loan that you owe them for. But they never gave that to you. They kept it. And according to modern money mechanics, 9 times the amount was deposited in that demand deposit bank account. 9 times the amount of what your property cost was deposited into the bank. And then the bank kept all of it and made you start paying on this scam that you're never going to have it paid off. Now, let's get back to the real estate deed fraud, okay? Because I don't want to get too far away from that, because that's really important. If you understand that, then you'll understand better why we do the things we do. So, the real estate deed fraud. Once they have your deed registered in their office, that allows the liens to be placed on your property. Now, do you know who places the first fraudulent lien against your property? The lender. The lender's attorneys. The lender. Remember, I just told you that the money that they're saying was a loan was generated with your own signature. So that means that your house was already paid for. Now, here's the thing that I tell people who want to get in my face and be smart ass. Here's the thing. If you did not own your house, the bank would not accept your signature on the mortgage. Chew on that for a second. Think about it. If you didn't own the house already, the bank wouldn't have accepted your signature on the mortgage, because only the owners can sign the mortgage. Yep. So when they registered your deed in the county recorder's office, that allowed the lender to file the fake mortgage against the lien to your property and force you to start making house payments. Check. do your homework. I've done my homework, and this is what I come up with. So I'm dying to see somebody come up with something different, okay? Because I have done my homework on this, and I've been talking crap for a while, and ain't no attorney's been able to make me shut up by showing me the thing. Show me the thing. Yeah. So yeah. So I had a guy, you know, I mentioned this in a video one day, and a guy called me, and he said, so if I'm buying a house, all I got to do is not register the deed in their office. It's like, yep, I think that would be. I said, I've never done that, but I've done this homework over here and followed the signatures and the paperwork, and this is where I'm at. But you need to understand that if you let them know that you know this and that this is what you're going to do, then more than likely they're not going to do the deal with you, because all those people at the table are all making bank. You're the only one. You get in the house, well, you're getting to stay in their house. So someone from the Facebook user says, I need you to put me on a plan together, guy neighbors, and I have to watch replay because I have to do something quickly. So this Facebook user, your name's not on there, so I have no idea who you are. So you guys have to remember that. So when you're coming here as a Facebook user, yeah, I don't see your name. So I have no idea who you are. When you come from, well, no, I take that back. Ike Turner, I can see his name. No, oh no, he's from YouTube. So the people from YouTube, your name shows up, so I know exactly who you are. So if I don't recognize you, then I'm not sure what your name is. So I have about 1, 2, 3, 4, 6 or 7 Facebook users. So I could say Facebook user 1 and Facebook user 2. Okay, never mind. Sorry, I got carried away. So let me get back on the program here. So this is what the constructive delivery is, and you can see how that fits. Now let's take a look at the actual statute. Before we take a look at the statute, though, I want to show you guys this. So this is part of the statute that I chopped up. And there's that word constructively right there. And then right here, we start talking about codes. So a code. So you have statutes, codes, and ordinances. Or maybe it's ordinances and codes. Now, anyway, so they're all low. The statute is what the state, uses, and that's what they use to foreclose on you. And that statute does not have the necessary elements to be considered a valid law. And neither does the codes, and neither does ordinances. And anything that the municipal court is enforcing is BS, because municipal court does not have judicial authority. And that's why they're down the street and not connected to the state court building. Has anybody ever wondered why the hell municipal court, traffic court, and all that stuff is down the street? It's because it's not connected to the Constitution and is not connected to state court. Municipal court, and you can look up the clerks, the state court clerk's manual for your state, and look it up yourself. I found it in the state court manual for the state of Kansas when I was fighting my 3 $10 seatbelt tickets. So municipal court gets his judicial authority from the city ordinance, from a damn ordinance. Ordinance is just a rule that these fools put together. So I'm like, how in the hell can a corporation provide judicial authority to itself? Are you kidding me right now? Yeah. But they do, and they get away with it all day long because most people have no idea. And the people that do have an idea are kind of scared. And me, I don't let fear dictate my fate. I don't, and you might can see that, and yeah, because that ain't a good thing to be on. So right here, they talked about the codes section. This is what they use. And we're going to take, and then down here, they have some more double talk. Right here was real interesting. Right here is real interesting because, and I think this is what makes people think it's a law. So deeds. So what this is giving an officer of the corporation the authority from the corporation to register your deeds in their office. This does not force or provide any law that mandates you have to file your deed in their office. All this does is makes it clear that the person that they choose, this recorder or records or whatever the hell they want to call them, has the authority within their corporation to take your deed and do what they're doing with it. But right here, it says deed, mortgages, and liens of all kinds. So we're talking about the different things that they can record. You can read this if you want to. I'm not going to read the whole thing. But right here, it talks about the deeds, mortgages, and liens. This is all the stuff that they're able to record. Deeds, mortgages, and liens of all kinds, which are required by law to be recorded in the office of the clerk of the Superior Court, which are against the interest in third parties who have required a transfer. Okay, so that's what they put in this crap to make people think that you have to record your stuff. So if they say which is required by law to be recorded, then what deed, mortgages, and liens, what law is there that says you have to record your stuff? There's no law that says you have to record your stuff. So there you go. That's BS. And this is how they play on the words to make people think that you have to record your stuff. And we're going to look at the whole law here. As soon as I find my cursor, I got two screens open up here, so my cursor's okay. So this is the Georgia code. A code, and you can Google what a code is, and you'll be like, what? Now, sometimes when you look up what a code is or what an ordinance is, it'll say something that's been enacted by the city, whatever. Okay, and then when you actually look at the code, it says it's adopted. It's adopted, and you can look up the word adopted too. I did that, and I was like, oh my God, this is such BS. It's ridiculous. So let's just flip through this. And duty of the clerk is to record certain transactions affecting real estate, property, personal property, prior or recorder instruments. This is the same thing that we just looked at. And right here, it starts out talking about the duty of the clerk to record certain transactions of private property, recorder instruments, and return rights to all parties. Clerk of the Superior Court shall file index on a computer program, and they just talk about, permanently records, managing, and they come in with the code right here that they use, saying that their officer of their corporation is allowed to do this. The following instruments conveying property, transfer, so then you can scroll down and you can see all of the things that they want to get from you so they can steal from you later. And while I'm on this, the reason this is so important is because I have people in the group that are facing foreclosures and they were never behind. I have people in the group facing foreclosures and they have all of the documents to verify that their lien, that the lien was released and everything was paid. So how the hell can these people be in foreclosure? Well, their information, property information, was registered in the county recorder's office. And during the COVID shutdown, everybody was stuck at home except these attorneys, these fraudulent, thieving ass attorneys were still going. And I have several people tell me this, These attorneys are still going into court and doing stuff and preparing. And that's the reason why I lowered my prices from $850. Well, I already came down from $1,700 to $850. And then I lowered them from $850 to $500 for the lawsuit packages. And once I did that, then I couldn't provide the same phone support because of the increase. And that's one of the reasons why we're doing all that. Okay, but yeah, so what do you think these attorneys are doing in the county recorder's office? What do you think they're doing in the title office and going into court? They're lining it up so when the floodgates opens up, they'll be able to start smashing people. And what I think is going to happen is they're going to start smashing the people who've been dragging their feet saying, I got time. The moratorium has stopped everything. I got time. So I'm going to sit on my ass. I'm sorry. I'm just going to call it. I'm going to sit on my ass because I got time and I'm not going to worry about it. I'm going to do whatever. Now, with that being said, I do understand that some people are struggling financially and they're not sitting on their ass. They just are having trouble getting it. But there's a lot of people who are doing just what I just said. Okay. And what's going to happen is when the gates open up and everything starts rolling, what's going to happen is you're going to be dragged into eviction court ASAP. And you're going to say, well, wait a minute. What about the process? Well, I got the paperwork right here showing that we filed this stuff and you didn't respond in time, so you were defaulted. Well, wait a minute. There was a moratorium. Well, check out the facts on the moratorium. The moratorium says they can't kick you out of your house. The moratorium does not stop the litigation. So that's what they're going to do. You watch. That's what they're going to do. They're going to come back and say, dude, we filed this stuff. You didn't respond. Well, wait a minute. No one said anything to me. That's not my problem. You got 10 days, wham, to get the hell off the property. And that's the way it goes down when you get in eviction court. Eviction court can only make a determination on immediate possession. They cannot make a determination on a title dispute. And this is what we do. In our program, you create that title dispute in a higher court, and you use that to control these fools down here and make them sit the hell down and shut up. And in the non-judicial package, I have documents that you can use in a non-judicial package to challenge eviction court's jurisdiction and a notice of removal to remove the case from eviction court and connect it with your title dispute. People are doing it all day. You just have to follow. And eviction court can't do shit about it. They can't do anything about it. I had one lady go down to tell them, can you guys send my file over? Yeah, I love it. And Shamel Maxwell, they told her, your legal team has really come up with some powerful documents. She said, yeah, my legal team be all over it. And if you guys don't be careful, you're going to be added into the lawsuit. I love it. She's all over. She ain't playing. And she actually has stopped the sale of her dad's house. She vacated the judgment against her dad's property. And then she had to stop the sale 3 more times. Yeah, they kind of getting tired of messing with her. I asked her one day, I said, so Shamel, you know, I need to be able to tell the people in the group, because most people in the group have no idea how much time you got to spend on their ass. So I asked her, so how many times do you think you called in to the courthouse to talk to the clerk about this crap they're trying to pull? She said, well, Mr. Guy, she thought for a second. She said, almost every day. She said, when she calls them up, they're like, hello, Miss Maxwell. But that's what you got to do, okay? Because you have to make them understand that you're going to be a pain in their ass and that you are willing to do whatever it takes to get to stay in your house. End of the story. So let's get back to this. So you can see here that they have a pretty much double talk. There's nothing here that says you have to put your deed in their office. All this talks about is what this person's job is, what this officer of the corporation job is. And then down here, You can see when we talked, it talks what I had pointed out in the underlined in the red. They file the required by all the liens of all kinds, which are required by law to be recorded in the office of the, but they don't say what law. Yeah, they don't say what law. So, they're making this shit. So let me click this out. So I think that's all I want to share. Okay, so now we're back. So Ike Turner says, nope, he didn't get a copy of his deed. Yeah, dirty tricks. That's what they are. And you know what? When you get into court, they're telling you to do all this stuff and jump through these hoops. People don't realize that the rules that you have to follow are the civil rules, the federal rules of civil procedure. Okay, that's it. Any rule that's not in the federal rules of civil procedure, you are not required to follow. The local rules are structured by the court, and the purpose of the local rules, in my opinion, is to speed things up through the court faster. So that's why they do that, and you do not have to follow that. So, and when they start telling you this stuff, now I tell people, educate yourself. Find out where the filing requirement statute is for your state and read it, because you'll find out that filing requirement statute is pretty liberal, and all this extra stuff that they're telling you to do is not in there. Now, one of the things that we wanted to talk about is I had a member who was trying to get her stuff, and she moved. She was trying to send her stuff in. They were giving her a hard time. They keep sending it back to her. And I have the other family member that I was helping. Okay, they've been ignoring our stuff and tilly-wagging around, and yeah. So this is what we did. The document that we filed to dismiss for failure to litigate the case, and the jurisdictional challenge, we attached a jurisdictional challenge to it with an affidavit. We attached to it, and we filed that in court. We also served the judge a copy, and we made the judge sign for it, because what they're doing is all this shenanigans, and none of your shit is getting in front of the judge. So they're stalling, they're calling it continuance, they're doing all this stuff, and none of it is getting before the judge. So they're protecting the judge so the judge don't see your shit, so the judge don't have to rule on it. But now you're sending it straight to the judge. So we've been doing this for over a year now. I think it was a year. I think it started last October. So it's about a year. And she has never had a hearing, which is good, because we ain't trying to go into court. And she's still in her house. That's her number one goal. But we're getting tired of this, so we need to wrap this up. So we stepped up, and we filed that. We served the judge. And now, after the judge got served, they called her. And they told her that, the judge got the thing, but the judge is out of town right now. So, yeah, that's all right. I know the judge might be out of town right now, but that somebody's got her stuff. And now it's changed. So she's been calling them back, so what we did was, since the attorneys were defaulted already because they couldn't respond to none of the last 3 or 4 documents that we filed, we defaulted them, and we demanded the judge rule on the motion to dismiss for failure to litigate the case. We demanded the judge rule on that from the bench, because the other party's been defaulted, and we didn't even send them a copy of it. And they called her about that, but they told her the judge was out of the office and she'll need to call back. And so she's been calling back. And so I'm sure they're having some meetings trying to figure out how the hell they're going to get off underneath this rock. But I got another rock that we're going to stick in their face. And we'll talk about that here in a little while. let me get back on track here so I can make sure that we so now we're going to talk about what's new, and then we're going to wrap this up because it's been going on a little bit over an hour. So does anybody have any questions about the program so some Facebook users said, well, when I'm going to show the love. Well, that would be great. And I have a lady in the group, in the online course, who was really impressed when she started looking at the curriculum, and she actually purchased another enrollment for a new student. We gave that away last week on the radio show. So that was really cool, and that was her paying it forward. So I actually gave away a enrollment in the course as well, because I figured if she can do it, I can step up and do it too, because I ain't letting nobody get too far ahead of me. So we got 2 students enrolled in the online course, and we're hoping to have the progress of those students in our feeds on our maybe, I don't know about the radio show, because I'm not sure how that's going to go, because this is the second show that I missed, and there was still a show that went on. It looked like they just chose to do the show with someone else, which is fine. But I think I actually see more people here on YouTube and Facebook listening to me than on the show. So I might just focus on this. I don't know. We'll see how it goes. But I'm working on a new course that is going to teach folks how to block the code enforcement and eliminate property taxes. So it's going to be kind of a 2-punch in one, and I'm just now putting it together. So I'm anxious to get feedback from people who invested in the eliminate property tax lawsuit package. I think a couple of weeks ago I had about 8 or 9 people when I had it on sale invested in it, and I think that feedback is going to help me put this package together that we need. So people who have Airbnbs or people that are about to get jammed up with this property tax will have a good solid program with videos and everything, just like the online course. Now, I structured a new document called an acceptance of the attorney's offer to contract. And well, it's actually more than a document. I'm not sure what I'm going to call it yet, but it's pretty badass. And we're using it right now. The family member is using it. So we're kind of going to get a feel how they respond. And basically they didn't respond properly to it. So they're in default. And let's see if I have, I'm going to do a screen share one more time. And I'll show you guys this, and then we're going to wrap it up, because this is okay. So this document that I put together here, and I've been working on it for a while, and I'm not sure how I'm going to market it or what I'm going to charge for it, and it will be something that someone that has experience needs to use, because it's quite different. So basically what it is, and you can read it here, this is the instructions with it that come with it. And what this is when an attorney sends you something that they have signed, it's an offer to contract. So what we did was we used a notice of appearance because we've the person that I'm helping, we went through six or seven attorneys. So the notice of appearance for the attorney that's sticking around now after the jurisdictional challenge and all of the stuff that's still in our face, we did this to him. And what you do is you take their offer to contract, and you draw a line on it opposite where the attorney's signature is, and then you sign and date it. And you attach that to your acceptance to the contractual offer. And in your acceptance to the contractual offer, when you sign it, you're also going to add your terms. because these contracts that they're forcing you into only have one signature on it, and that's yours in most cases in foreclosures. But when they drag you into court, they're the only signature on it that's actually trying to steal your property. So you sign it, draw a line, sign it, date it, and then you fill out the acceptance, the attorney's contractual offer document. It's like 3-4 pages. And you do the same thing you do with the lawsuit package. You just place the red font with your information. And you put in there, I think we're asking for $1,000 a day for the first 10 days. And then it moves up to we're asking for something else. And you can kind of read through this and see so basically what you're doing is you're accepting their contractual offer, you're signing it and turning it into a real contract, okay? And then you're adding your terms to the contract. And then you serve it to them. So they have to sign for it. First off, you take it to the notary and you have it signed and notarized. And you pay the notary to accept the return service. And in the document, you're telling the people they have to respond directly to the notary, or any response directly to you is going to be considered an invalid response or non-response, and you're going to be in default. And they never send it back. They never send it back to the notary. So they usually send it straight to the person, which they did. So now we're headed to the notary to get a certificate of non-response. And when you get the certificate of non-response, then you attach it as an exhibit to your letter of non-response that you have signed from the notary and everything too. So it's a 2-part deal. And then you send them their certificate of non-response every month for 3 months. And then once you send it for the third month, then you place it on the public record that they're in default. And then you file a lien against the attorney's bar card, against the attorney's license. And then you file that lien on Brad and Dunn Street. And then once you do that, then you would send a copy of all of that to the Bar Association. I would serve a copy to the Bar Association and to the attorney. And that puts you in a position to, I don't know, to own them. Yeah, it's pretty stinking slick. And we're in the process of doing that right now. So I know the judge is supposed to get back with my friend, or the court clerk, or whoever it is that's contacting her, is supposed to get back with her and let her know when the judge is going to rule on her stuff, or what. Yeah, we got him hemmed up real good. We got him hemmed up real good. And this is going after the attorneys now. And the attorney is not going to be able to climb out from underneath this rock. And we're still in state court. We have not filed the wrongful foreclosure lawsuit in federal court like all of you are doing. And I wanted to try this to see if we could put together a program to smash them in state court. And that's what the jurisdictional challenge was, because this case was the first case we used it in, and it stalled it off right away. But you can't let it sit on the judge's desk. If they don't respond, when they don't respond, you need to address it immediately. That's the big deal. So you can see that's and I love this. I cannot wait till we get this figured out and people get to use it. And it's really funny because the attorney went and filed it in court and made some shenanigans, and we're not even going to respond to it because the attorney's in default. And the judge is already saying, well, they're already the clerk saying that, the judge is, received this stuff. So we know the judge received it. So we're not going to respond to them, because if you respond to them, that gives them jurisdiction and gets them back in the door. So we're just going to leave them set right now because they're in default name. And besides, this is not anything filed in the case. The judge ain't going to have this. They're going to look at that and like, oh, no. And the sad thing is, if he wanted to file any case, he could force them to, yeah. So when they're in default, it's a problem. So that's something new that we're working on. And when I get that figured out, I think I would like to have at least one or two more people use it before I market it and put it out there, because like I said, this is, and you guys got to remember, what I'm doing here is new. I don't see anybody else doing this. So I don't have all the answers for everything, but we can figure some stuff out. And then some stuff you guys are going to have to figure out, the procedural part, because I'm not an attorney. So I don't know. I learned the rules for stating a claim, and I made a new, actually I think I've added 7 courses to the online class, 7 lectures to the online course. And the main lecture that I added was how to properly state a claim for relief. Now, if you have invested in one of my lawsuit packages and putting your stuff together, the videos on how to state a claim for relief are paramount. You must watch them and learn from them, because generally I don't do the way they do stuff, because I'm hard-headed and I like going in, stomping on stuff. And then but we've had a few people that face this, want to dismiss it because of the they want to dismiss it for failure to state a claim. And so I decided to go ahead and look, and so I go, oh my God, this is easy. I'm like, yeah. So we're doing it, and I put together a cheat sheet that you can use as a guide to make sure that you're structuring your document in the manner that you need to properly state a claim for relief. Now, stating a claim for relief, they're asking for a short, plain sentence, the statement of jurisdiction first, a short, plain sentence of or why you should get your money, and then you need to put down there what it is you need them to do. Okay, and that's it. But that's not it for me. We're going to add that to the front half, but we're still going to add all of the stuff that we got in the document to stick up in their face, because remember, our goal is not to go to court. Okay, our goal is to make them go sit the hell down and leave you alone. That's our goal. So Ike Turner says, please, before you go, we explain the motion to moot. The motion to moot. So if you Google what moot is, you'll see that the motion to moot is just a motion to make everything stop. And generally, you're asking to moot everything. Like, say, for instance, you move the case to federal court, then you want to moot everything in state court. Or say for jurisdictional challenge with an affidavit. We stuck that in their face, and they started playing around and stalling and doing stupid shit. So what we did was we came back with a motion to moot everything that they filed in the case until they proved jurisdiction on the record. And that let all the air out of their tires. As a matter of fact, they were not able to respond to the motion to moot jurisdiction until motion to moot everything until jurisdiction put it on the record. They were not able to respond to the motion to moot at all. So they asked for a continuance to respond to that. They tried to respond to the jurisdictional challenge with an affidavit, but they didn't respond by counter affidavit, and they didn't address nothing that we said in it. So they didn't respond to that either. But they, for some reason, they could not touch the motion to moot. And then when their time, so we just went ahead and defaulted them, because we didn't need to wait on that, since they didn't properly respond to the jurisdictional challenge with an affidavit. So we just went ahead and defaulted their ass, because I figured they probably wanted to wait. They probably thought we'd wait and follow their rules and wait, so then they could say we were out of time to respond. I don't know what the hell they had going in their head, but we just smashed it all up, because we don't wait. In this program, we don't wait. Okay, you go. And if you make a mistake, we can correct it. And this is the problem that most people don't realize. They cannot throw you out of court for want of form unless you go sit down and give up. Okay, so don't worry about that. Stick her in their face. And when they're kicking you out of court, they have to tell you what the problem is. Mm-hmm. So there you go. That's what the motion to moot is for. Now, that motion to moot can be used anytime you got to jump on them and they ain't responding correctly. So my goal is to teach you guys these strategies so that you can start using them yourself. Okay. That's important to me because I'm not trying to be in the middle of everything. I need to get you guys up and running so you can get on out of the way so the next person can step up and start learning. So, and if, number one, I always ask people, don't send me your stuff, your documents and stuff unless I ask for them, and you have consent to do so. Okay, that's number one. And number two, people need to understand that you're on a time frame. I have people tell me, oh, I got time because I got 10. No, you don't. Okay, you got that time if they're following the rules, but you already know they ain't following no rules. So people tell me that, I was like, oh, geez. Because usually those people drag their feet, and no, you don't have time. You got to get the stuff stuck in their face. Now, I want you guys, if you get something in the court from them, don't call me the same day maxed out, okay? Call me if you're like have anxiety about it, call me in a few days, okay? Because I don't like talking to people that maxed out, and I don't like talking to people that are driving, okay? I talked to this guy who was driving one day for like 45 minutes. And explained all of this stuff. And when he got home, he called me back to explain it again. I'm like, dude, we just went over that for you. He's all, but I was driving. I'm like, you're killing me. Okay. I said different to him than I said to most people. Okay. Because yeah, that was bad. So don't call me while you're driving. Please, please. Now, people have to understand too that we're all working together to get this done. So, and I keep that in mind too. Sometimes I get a little pushy as a coach, and the goal is that I want to teach you guys how to do this yourself. Okay. So if you get something from the court, don't call me freaking out. Don't call me until you figure out what it is you got. And you do that by Googling the words. Whatever words on the document you don't understand, Google them. And when you see what the definition of the word is, you should be able to figure out what the document is. Okay. Call me after you figure out what the document is and what your game plan should be for going forward. And then when we talk, if we talk or when we chat, then I'll have an idea. When you tell me what it was, when you tell me what the document was they sent you, I already know what your game plan should be or whatever. And in most cases, I'll know if you're chopping up the title of the document and not telling it to me right. And I'm going to make your ass run. Okay, never mind. I'm not going to make you run. I'm getting carried away. So you need to make sure that you figure out what you got or what you think you got and what your next game plan should be based off of your research. Okay. Then when you call me, hey, I got this crap in court. This is what they're saying. I looked it up and this is stupid as hell. That's what most people say because their stuff is ridiculous. And this is what I think I should do. And that to me, I was like, all right, because I'm here to help you figure out how to do this. And you got to do these things and figure this stuff out in order to be able to take the wheel. Okay. You got to take the wheel yourself because you already know having an attorney at the wheel is going to run you in the ditch. And I tell people all the time, you don't have to pay somebody to screw up your case. You can screw it up yourself. Okay, let me be serious, but that's true. So that's all I've got tonight. If you guys have questions or something that you'd like to have me talk about in the team meeting, send me an email or message me in the group, tag me in the group, message me, or send me a private message or something. And then I'll make sure that I add that to the list. And then when I get like 5 or 6 things where we can spend a little bit of time, because I don't really like to do like 3-minute videos. So when we get enough things on the list where we can spend an hour talking about it or whatever, then I think that would be beneficial to everybody to spend the hour learning the same questions that I think other people have. So we're going to have team meeting. This is team meeting 1, and that's the way I'm going to put it, as team meeting 1, team meeting 2. And then that way, if you need to understand something or look up something, you can go to team meeting 1 or look up or check out the videos on my website. because all these will be downloaded on my YouTube channel. And they're all right now streaming on all my Facebook, all 5 of my Facebook pages. So, oh, and remember, if you guys have that HOA document, the indenture trust agreement, or the covenants and restrictions or whatever, I would sure like to have a copy of that so I can review it to make sure that what I'm putting together is fire. So thank you guys all for hanging with me tonight, and I hope you all learned something. And I will see you guys on the next stream. Have a great day and good luck.